Hey everyone, Harry here to talk about Mark Meadows' testimony in support of his motion for removal and his overall strategy. All right, so yesterday, dramatic moment. Mark Meadows takes the stand. This is in federal court in Georgia, where he is trying to persuade a judge, and he has the burden that the case should move from state court where it was brought to federal court. Now, people have given reasons why he wants to do that, but I think they've missed the punchline here. But for starters, when you remove a case, it's still the same case. It's just tried in federal court. The theory dating back from, way back when is you wouldn't get fair process in state court in certain instances. For example, if you're basically a federal official who was doing his or her job. That is Meadows' claim and his argument for removal. I'm the chief of staff to Trump, and in the conduct alleged in the indictment, that was just me being chief of staff. Now, second major point, why was it a dramatic moment and indeed a surprise? Almost everyone, myself included, had said he's not going to testify. Here's the reason. Meadows had been the model of someone who'd kept his head down while everything else was going on, and he has very good lawyers. And it seemed that it's always precarious to take the stand. As you know, often in trials, defendants don't do it. And here, this would be in advance of the trial. And so Meadows, one, would be subject to cross-examination and wouldn't be able to claim the Fifth Amendment. And his story, he would get locked into it. And there are certain things that he said that he's now locked into. And that's something you really want to avoid. But, and here's, point three, the Meadows team obviously decided, and my sense is, a long time ago, that this is the most, it's just too important, and he had to take the risk. Notice he's he's run quite the slalom course and stayed out of trouble. In the January 6th committee, he gave over some documents and they shut them down. They held him in contempt. They referred it to the Department of Justice. Department of Justice didn't bring charges. Then in the January 6th investigation by Jack Smith, he's not one of the 6 co-conspirators. He seems to have cooperated in some measure, but we don't know exactly how, but not, by taking a plea and fessing up to any kinds of crimes, but just grudgingly, whatever he had to do. And now his point of fullest exposure, Fulton County, where he's been, alleged to have joined a big RICO conspiracy, looking at a long sentence in Georgia State Penitentiary. And the card he wants to play here is removal, yes, but followed by immunity. So let me explain a little more. It's a 2-step dance for him. He wants the case first to be in federal court, and then he wants to be able to bring an argument that he is immune from federal prosecution, because basically what he was doing was really discharging federal law, and that's what you need to do to be immune. That's a little bit more than to remove a case, which you can do if you show you were acting under color of state law. So this is a high-risk strategy, but he obviously concludes that the risks of facing indictment and trial in Fulton County are greater, and he wanted to avoid it. All right, so dramatic moment, he takes the stand. And he gives his own account of things, under the questioning of his very able lawyer, George Terwilliger, a former deputy attorney general in the Department of Justice. And his mantra is, chief of staff, it's a 24/7 job. You always have to be there. You're not necessarily trying to further what the president is doing, but you are trying to protect the president's time. You are trying to cross things off the to-do list and make things happen. And what the president does, you do. And he made a pretty credible case that for much of the time, he's acting the way a chief of staff acts. Now, the state has made this big claim. Let's go to what this state is arguing on cross-examination. First, they're arguing that there is a federal law called the Hatch Act, which says that federal employees aren't allowed to electioneer and act, try to work on campaigns. You can't work on a campaign as a federal official. All kinds of restrictions. You've got to go off site and document things, etc. If that claim carries the day, Meadows is in a world of hurt anyway, because obviously this is campaign work in a way of thinking about it. But his basic submission is, where the president does political things, that's clear. And wherever the president goes, there goes the chief of staff. So it's a forced move, and the Hatch Act doesn't really apply in the same way. As I say, he's got to make that fly or he's out of luck anyway. But then the real focus, and this is the risks of and the potential upside of testifying, and this is the kind of ultimate, the January 2nd phone call and its prelude with the Georgia Secretary of State, Raffensperger. There, it sure doesn't look as if Meadows is, just doing chief of staff like things. It looks like he is all in the effort to try to, in his own kind of milquetoast way, to try to push on the Secretary of State. He tried to call him a few times in advance, and the Secretary of State ducked his calls. He participates in the call on January 2nd and says, "Can't we, try to advance this process and delay things a bit?" He says, "I promise you, there are more than 2 dead people who voted," because that was a Trump claim. He's right; there were 4. And, he sure seems to be enlisted in the effort to get Raffensperger to delay the tabulation of the electoral votes for Biden, their rightful winner, in order to serve Trump's purposes. And that really matters because it just doesn't seem to be a valid federal purpose at all. And that's what he really is going for, showing it was for a valid federal purpose and did no more than he needed to serve that federal purpose. In other words, the test for immunity, which if you get it, it means the state criminal charges go away, however serious they may be. There have been cases involving murder where the federal office holder was able to receive immunity, and that's just the end of the story. So that's what is up with Meadows. Now, the judge suggested it was an issue of first impression, so that it could go either way. He wants to do it pretty quickly by the time of the arraignment, scheduled for the September 6th or 8th, I believe. And I think the real focus is going to be January 2nd. Can Meadows, who bears the burden, make a credible claim that he was really just, doing legitimate federal work when he was joining in the effort to pressure Raffensperger? Recall, we have this whole tape because Raffensperger had the forethought to push record and get Trump on tape and everybody else. And it's a really, killer piece of evidence against him that's going to figure big time in the trial, no matter what. So he's trying for removal, which is a fairly low standard. You just have to show you were acting under color of your office. And that's the issue that Jones says could go either way. It's almost how you characterize it. Is he being like a chief of staff, or is he fomenting a coup? But it's really avails him Very little unless he can make the immunity claim happen. That's what he will bring immediately after, should he win removal. So everyone's, really will be focused on that. One more quick point is people are suggesting, that'll really affect how things go with the other defendants. There are 5 in all, counting Meadows, who have moved for removal. Jeff Clark is one, and then 3 Georgia electors. I don't think so. I think removal is a very fact-specific kind of inquiry in terms of how people were acting. The Georgia electors, they're saying, it's a federal office, being an elector for the president, but I think they're really acting under state law. And then Jeff Clark, his conduct in the indictment all has to do with one thing, where he's wanting to write a phony baloney letter telling Georgia on behalf of the DOJ that there's something rotten afoot in the counting. That was a flat out lie. I think it's going to be very hard for him to show that was part of his, regular duty, so that he should get removal. So the game here, I think, is Meadows, and the game's a 2-part game, and the second part matters most, but he's got to get over the first hurdle of removal. So we'll be waiting until for 10 days or so to see what Judge Jones does with that, and then really focused, should he permit Meadows to remove the case, on the certain next step of seeking immunity. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.